Hello and welcome to this webinar hosted by the Extractives Hub. Today we will be addressing the Ghana-Cote d'Ivoire adjudicated boundary, the role and risks of concessionaires. My name is Peter Becker. I'm a Dutchman and I am professor and chair in international law at the Center for Energy, Petroleum and Mineral Law and Policy within the University of Dundee in Scotland. I'm also a partner in the UK energy firm CMS, Cameron McKenna, and Barrow Olswang. And I'm a former staff lawyer in the Registry of the International Court of Justice, which is the principal judicial organ of the United Nations that's seated in The Hague, and it has been the frontrunner in adjudicating maritime boundaries. Now, our presentation today will underscore how maritime boundary delimitation is part law and part science, as geoscience, the two disciplines being intertwined. And as a lawyer, I wouldn't dare giving boundary advice without the assistance of a geoscientist. So I am pleased to team up today with Robert van der Pol for this presentation. Rob, who is Canadian, is the creator of Keras Lots, the world's most sophisticated software for plotting boundaries. And I will let Rob introduce himself.
Thank you very much, Peter. Again, from myself, thank you to the Extractives Hub for allowing us to present this webinar. As Peter mentioned, I am the geoscientist in this attached at the hip group of two, Peter handling all the legal side of. Today's webinar will be focused on the Ghana-Cote d'Ivoire adjudicated boundary, and at the end we will do a rather short walk through another up-and-coming boundary that's of equal interest to Ghana. As Peter mentioned, I work with Fugro. I'm the global director for Law of the Sea for Fugro, managing 162 countries. For the last 15 years, I've been working with Fugro. Prior to that, I worked 15 years at Keras, where, as Peter mentioned, I worked on and we developed at Keras the Law of the Sea GIS software for the United Nations. Now, just before we begin, just some comments. Every effort has been made to ensure the accuracy and graphics and figures contained in this presentation, although nevertheless, it's illustrative, indicative, independent, preliminary. And please, any facts and figures contained in the presentation should be for the permission of both of us, should not be used without permission of both of us. Peter.
We have public sources to which you, of course, can refer, and we would like to bring to your attention that particularly with regard to the Ghana-Cote d'Ivoire adjudicated boundary, we have several papers on our webpage, which is at the Dundee Ocean and Lake Frontiers Institute and Neutrals, or Dolphin, webpage at the University of Dundee. And the web link is on the screen. It's sites.dundee.ac.uk/dolphin/. And you will see various tabs. One houses outputs prepared by Rob and myself, including on the Ghana-Cote d'Ivoire boundary. It's a post-ruling analysis that we will present to you today. So we will be sharing figures from that statement. We also have prepared a peer-reviewed analysis for the American Society of International Law that is available through the Insight series at the asil.org website. Next slide.
Okay, so Law of the Sea itself is a global marine mapping application that impacts 162 countries. Here you see a nice overview figure of the entire world in Mercator projection. It's showing all the global EEZ waters, which is just around 169 million square kilometers. So all of our Law of the Sea applications in today's presentation will take place within EEZ waters and some outside those red lines shown for the extended continental shelf. The red polygon or circle in the middle is actually the area of focal point for today's analysis and today's study. So what is the status of maritime boundaries around the world as of today? So that being taking us into the end of December 2019. There's approximately 501 EEZ maritime boundaries in the world. 250 of 500 are signed and or in force. So that sadly is only about 49.9% of the world that is safe from the law of the sea point of view. That means that 50.1% or 251 of 501 are unresolved and in dispute. And that means today, 1 out of every 2 maritime frontier boundaries are disputed. And that's what was faced with Ghana, where they needed to go to the court to resolve one boundary and the other one remains unresolved present day. And that sets us up nicely what we are going to speak on today for both frontiers for Ghana. Law of the Sea itself is a global mapping application that needs a global mapping database. 14 years and 95 terabytes worth of data that I've been involved in with Fugro means that we constructed this wonderful global Fugro Law of the Sea database. It is proprietary. It contains an amassed information relevant and relative to all 162 coastal states. We have to date completed 1,800 plus projects dedicated to Law of the Sea in 142 countries. You'll see the red zone there. We're going to only be using the African compilation for today's analysis and today's discussions. So some Law of the Sea background information. This is going to be a preliminary review, Ghana versus Cote d'Ivoire, unresolved disputed maritime boundary. This next slide deck was presented at Upstream Africa Oil and Gas Conference in Cape Town, South Africa. And take note, this is from November 2016. So this is 1 year prior. This is Peter and myself joining up and doing analysis in a desktop study for the region, specifically looking at the unresolved boundary. So we started this work actually back in 2015. So here is our desktop study regional review area. This is the relevant area of interest. You'll see we cover a portion of Liberia, all of Cote d'Ivoire, all of Ghana, a portion of Togo, Benin, and Nigeria in this 1 to 4.5 million scale image. Step 2, baselines coming from coastlines. You'll see the blue line here. This is our analysis, preliminary, and we use those normal baselines to draw the red line, which is step 3, which is the 200-mile Law of the Sea EEZ limit. So this defines the EEZ waters. Step 4, any treated maritime boundaries. To approach this study, we looked, and there was only one on the extreme east, a treaty agreement by Benin, Nigeria. Step 5, putting in suggested boundaries. We have one here for Liberia and Cote d'Ivoire. We have some over here for Benin, Togo, and Ghana. But this is the focal point. We're looking at this line. And this was actually Ghana's suggested maritime boundary, albeit unilateral, one state's opinion. And absolutely opposite to that, Cote d'Ivoire had a complete different opinion. So here's their unilateral line, which is swinging well to the east. And this area of overlap, or the overlapping claims area shown here, is just over 31,000 square kilometers geodetic. So this is going to be the contentious area, and this is the area that the dispute needed resolution on. Back in the day, this customary line from the 60s showed that there was simple pencil and ruler done, took a straight line and ran a perpendicular, how Ghana approached it. And for Cote d'Ivoire, they looked at a complete different dynamic. We did some reverse engineering, Peter and I, and we found that taking a straight line through all the land terminus points is actually how Cote d'Ivoire approached it, to try and remove this dramatic concave indentation of their coast as a disadvantage to the convex nature for Ghana. And that's basically how they ran their perpendicular line. So that gives the Cote d'Ivoire line for how they approached it, which is a dramatic different approach to how Ghana approached it. Interestingly enough, and looking mainly at the east, if you took this Cote d'Ivoire approach, you'll also see that it would give some fairness for Togo and Benin in the region. But this is going to be the area of focus, and this is the area that we will focus on in the coming slides. Peter.
All right. So maritime boundary cases often involve and are triggered by competing claims to natural resources. And the case between Ghana and Cote d'Ivoire is a prime example. Boundary disputes are a key area of investment risk assessment for oil companies, or they should be. Now, with neighboring coastal states, problems arise when you have an oil field with one or more reservoirs, that is a single pressure connected accumulation of hydrocarbons that cross or straddle an international boundary which is in dispute or otherwise has not been delimited by the claiming states. And we see that in the Gulf of Guinea. So does the private sector have a role to play then in boundary disputes between two coastal states? After all, concessionaires are directly affected by a maritime boundary dispute. But as a rule, this is the purview of sovereign states. Oil companies cannot be formal parties to boundary cases. But foreign companies can and should work with the disputing states. The goal here is to be a help, not a hindrance. Help means providing geological or other data to both states if requested, or identifying experts like Rob and myself to assess the international law and geoscientific strength of each country's case, provided this is done in a neutral way. Foreign concessionaires should take care not to take sides with one state over another and refrain from aggressive lobbying. So not engage in a barrage of phone calls to a prime minister's office and asking, when are you going to settle this boundary dispute with your neighbor? That is not good practice. Next slide. All right, so the great Scottish philosopher Adam Smith wrote in 1759, and I quote, "Never complain of that of which it is at all times in your power to rid yourself," end quote. And the advice given by Adam Smith addresses the issue of empowerment. Now, while international oil companies have limited power with respect to resolving maritime boundary disputes, coastal states have the sovereign power to rid themselves of their maritime boundary disputes one way or another. And in terms of policy options, coastal states with overlapping claims to maritime areas have a basic choice between finding a bilateral solution or seeking third-party assistance. And the United Nations Convention on the Law of the Sea, or UNCLOS, calls for negotiation in good faith of what it calls provisional arrangements of a practical nature, pending final delimitation of an exclusive economic zone, or EEZ, or continental shelf. That's a treaty obligation. And examples are the creation of a joint development zone, where the disputing states agree to disagree on the boundary and proceed to joint development of an overlapping claim area, or international or cross-border unitization in situations where a discovery is made. And these instruments enable the decoupling of questions of joint development from questions of sovereignty and sovereign rights. Now, the September 2017 ruling in the case between Ghana and Cote d'Ivoire is especially instructive regarding the legal obligations of neighboring coastal states with active offshore oil blocks, but lacking an agreed boundary or provisional arrangement for joint exploration and exploitation of hydrocarbons pending agreement of the common boundary. As a matter of fact, Cote d'Ivoire complained about Ghana not having entered into good faith negotiations to conclude a provisional arrangement. But the tribunal dryly pointed out that Cote d'Ivoire could not be heard complaining because it had not asked for a provisional arrangement. Now, the disputing states can also seek to delimit the disputed boundary through negotiation or through non-binding mediation or conciliation by a third party. And as a matter of fact, Ghana and Cote d'Ivoire had entered into negotiations on a bilateral level for some 6 years and 10 rounds, but that did not result in an agreed boundary. Now, the boundary dispute can also be submitted to a third-party adjudicated solution, either through ad hoc arbitration or adjudication by a standing or special tribunal. And that's what happened in this case. Ghana availed itself of the dispute resolution mechanism of UNCLOS and sued Cote d'Ivoire based on a mechanism in Annex 7 of the UNCLOS, whereby it could form an arbitral tribunal to adjudicate the boundary dispute with Cote d'Ivoire. And then Cote d'Ivoire agreed to transfer the case to a special chamber of the International Tribunal for the Law of the Sea in Hamburg, which was a first. And that 5-member tribunal then got the case. Now, self-help through the use of force is prohibited by the United Nations Charter. A state is permitted to use self-defense only after an armed attack has occurred. But we have seen instances of states shooting at seismic or drilling vessels in disputed areas. And we'll refer to that later on when we discuss the Ghana-Togo boundary. Next slide.
Okay, this is just a quick review of the steps. This is done again in January 2015. Step 1, Ghana's claimed maritime boundary, as you see here, the black dashed line. You'll see also step 2, we need to look not only EZ waters, but the ECS. That is the western claimed area for Ghana to the CLCS. You'll also see that at the time, all their offshore concession acreage, all their PSCs were following their claimed line. Step 4, now we need to go and review Cote d'Ivoire's boundary. Suggested unilateral is the black dashed line shown now in the figure. You'll see that that is swung well to the east. Also, interestingly enough, they submitted an ECS claim to the CLCS, but it doesn't match at all their unilateral claimed line. All their offshore concession blocks did, though, in fact, follow nicely their eastern claimed unilateral line. When you go and take the 2 claimed unilateral lines, you can imagine there's going to be quite a clobbering of all the as-issued offshore blocks of the day. You also see I'm showing both the claimed ECSs by the 2 coastal states. First things first, a court could go and 100% side with the claimed line by Ghana, and then there would, the red dashed line shown, it wouldn't impact that many of Ghana's blocks. Or the court could 100% side with the claimed line for Cote d'Ivoire, and then it would clobber an awful lot of blocks. Now, some of those blocks actually are in the development and production mode. Here's probably one very good representation. Peter and I, in analysis, created the strict equidistance line, and you can see it does shift it a little bit towards the east, but the inset shows that in court cases, 5 in fact, and they're listed and dated, the one shown in the figure is Guyana, Suriname, that played out in a court case, and that could be a good logical approach. Now, keeping in mind, law of the sea begins from a land terminus point, and for these 2 neighbors, they didn't even agree at the onslaught of where would be the starting point for this yet to be resolved maritime boundary. The coastal frontier area is extremely poorly mapped. I've completed 5-6 projects in the region, and I know that the nautical charts are absolutely outdated. So we have some technology here called Fugro's 40 SSM, satellite seafloor morphology, and mainly it's to identify the nearshore, foreshore features for mapping. So looping back to another possible one the court could do, they could actually split the middle and just go and run a bisector line down there, trying to define equal 50-50, which obviously would be one of possible results. And actually the inset here showing a court case from Honduras, Nicaragua shows that that methodology worked for those 2 coastal states. So there is some past history in the courts that shows that that could be a possibility. Here's another possibility using the relevant coastline bisector strict equidistance line methodology. It starts getting a little bit complex, you start looking at the geometry and a whole bunch of other additional factors when you do the analysis. The inset there is from the Romania-Ukraine court case, Feb 2009. You'll see that the courts actually used that in 5 cases. And if this was used, you'll see in the figure 12 kilometers will be the shift at the 200 mile in favor or into Ghana. Now, another one that has come up and raised its head recently is the extended continental shelf considerations. In this case, you'll see I'm showing the two as claimed, and there's a large gap, so we don't know in the middle. That yellow conic area is probably based on the ECSs where it would be, and the inset shows the Bangladesh, Myanmar, and Bangladesh, India past court cases. Peter.
All right. Thank you, Rob. So a body of maritime delimitation case law or jurisprudence has developed through about 25 decisions rendered by various international courts and tribunals since 1969. And through a technique that Rob and I call reverse engineering, and relying on our legal and geoscientific expertise, we can apply the lessons from the case law to a given dispute and make informed predictions regarding its outcome. And as Rob has demonstrated, that's exactly what we did when the case was before the Special Chamber of ITLOS. Now, the International Court of Justice, which as I mentioned is my former employer, is the undisputed frontrunner with 12 judgments. But ICJ boundary cases on average take 5 years and 9 months to conclude. The shortest case taking 35 months and the longest a whopping 132 months. So imagine being an affected licensed concessionaire. You're facing uncertainty for up to 132 months. And in this case, what happened is that Cote d'Ivoire struck back after it was sued by Ghana and requested that the special chamber impose a moratorium for the duration of the case on all drilling. Now that request was adjusted by the special chamber in its discretion, but the special chamber still imposed a moratorium on all new drilling. And that was in place for the full 33 months that the case took to be adjudicated. Now, the International Tribunal for the Law was created under the UNCLOS, and which sits in Hamburg, has adjudicated only one boundary case, namely between Bangladesh and Myanmar in 2012, but it did so in a record 27 months. And then this special chamber case was the first to be submitted to Hamburg. There are also 4 UNCLOS Annex 7 cases that took 43 months on average, the shortest taking 26 months and the longest 60 months. So relatively quick compared to the ICJ. And the case law, that is the modern case law, also comprises 7 pure ad hoc tribunal awards over a 40-year period from 1977. And that is part of the body of case law where in the ad hoc case, the 2 disputing states would agree through a special treaty to submit their boundary dispute to a court. But as we will point out in this webinar, this is only a measure of last resort. The states do not have to go to the courts. They can use all of this wonderful case law and this methodology from geoscience to resolve boundary dispute amicably. Next slide. So that raises the question, how does an international court arrive at an adjudicated maritime boundary? What is the delimitation process? Certainty, equity, and stability are integral parts of this process. And these elements are reflected in a 3-stage methodology or approach developed by the case law. This is not something you will find in a treaty, it's case law. The court will start by determining what is called the relevant area. And it does so by identifying the geographical context of the delimitation, including relevant coasts, protrusions, and shore features such as islands. Then the court will establish a provisional line typically, but not always, by drawing an equidistance line between adjacent coasts or a median line between opposite coasts. And equidistance represents a geometrical approach to delimitation. It's objective. There are other accepted methodologies or approaches to maritime delimitation, including the bisector method, which is also geometrical, and various other methods that we will also demonstrate and were in fact invoked by the parties in this case. Now, at the second, that's the next stage, the court will consider whether there are factors calling for the adjustment or shifting of the provisional line in order to achieve an equitable result. And these factors are called relevant circumstances. And the case law favors neutral factors of a geographical nature, such as a significant disparity in coastal length, over area-specific factors such as oil concessions and oil wells, unless the parties have expressly or tacitly agreed on the location of these concessions and oil wells. And this was in dispute in this case. In fact, Ghana used the oil practice of the two countries to advocate a modified or adjusted equidistance line. And the line that was imposed or advocated by Cote d'Ivoire said that the oil practice could not be relied on in order to support a tacitly agreed line. Now, finally, and at a third stage, the court will verify that the unadjusted or adjusted provisional line does not, as it stands, lead to an inequitable result by reason of any market disproportion between the ratio of the respective coastal length and the ratio between the relevant maritime areas of each state by reference to the delimitation line. And this is called the disproportionality test, and its application could result in an offshore island being given only half effect or no effect in the delimitation. So this methodology was applied by Ghana and Cote d'Ivoire, and our analysis, which you can read at your leisure, goes through the arguments as well as the solution that was imposed by the special chamber, and then also the impact that solution has and has had on oil concessionaires of both countries. Rob, next slide, please.
Okay, law of the sea can be subdivided for applications offshore in EEZ waters and ECS, the extended continental shelf. This slide just shows you what the current state of play in November of 2016 was when Peter and I started looking at the area. You see that Ghana lodged two claimed areas. Back at in the day, Togo also lodged a claim, as did Benin, Nigeria, Cameroon, and Sao Tome and Principe. You can see the red area has a dramatic overlap by all 6 coastal states, all lodging claims for the extended continental shelf beyond the EEZ waters, and it's almost 21,000 square kilometers. So this just goes to show maritime boundary disputes and claims to the offshore are not only in the EEZ, but also the ECS. Now, law of the sea background information. Our legal and scientific review of the Special Chamber's final ruling for Ghana Cote d'Ivoire's maritime boundary is the focus of this portion of the webinar. This next slide deck is our actual figures we created for our 2 publications. And Peter mentioned at the opening of our webinar, here they are again. You see the websites, you see the insets. This first slide actually is taken directly from the final Special Chamber's ruling. This is called sketch map number 4 for their final boundary ruling. So before we begin our analysis, let's just look at some facts. We have here BP 55 plus. That's something that we need to review. It's sitting right here. So this is Cote d'Ivoire. This is Ghana. Here's the land terminus point. 1 to A, B, C, D, E, and F points are gazetted down here. So they're actually showing the lat long. A very, very tiny portion of either side of the coastline showing their baselines in blue for Cote d'Ivoire and in green for Ghana are here. So this is the final ruling. And interestingly enough, at point F, it then does an azimuth, which is dictated here, and it will terminate out, and it actually goes beyond the 200 miles. So it actually allows for considerations on the extended continental shelf itself. From our analysis, and again, these next slides are only the figures, so we will give the figures, but again, as Peter has mentioned, as have I, please go and seek out the actual full paper to support these figures. This black line is the Ghana-Cote d'Ivoire agreed upon land boundary, and at the time, eventually, Ghana and Cote d'Ivoire settled on BP 55. That's boundary pillar 55. Take note, it's at the mean high water mark. So that's what the two coastal states agreed upon. And then from there, you have the orange line, which is Ghana's claimed line in the court proceeding or court case. And in the blue line, you'll see Cote d'Ivoire. So that's the dramatic departing of the land terminus point. And this shaded area is the overlapping claims area. Now, interestingly enough, in this 1 to 2500 scale slide, here is what the special chamber did. They actually overruled the usage of this. They came up with their own. They named it BP 55 plus, and they actually justified it by placing it on what they said was the low water mark. Again, using extremely old, very small scale charts of the region. But what it's done is it dramatically shifted it 159.87 meters down the coast to the water's edge, but it also shifted it 18.43 meters east. Now, that's when they then draw and concluded that line that I just mentioned in the previous slide deck. But what the takeaway is by starting with a new position and defining a new line, you're going to clobber any and all offshore concession blocks that lies in proximity. So we actually have now a new starting point and a new set of lines. Here in figure 2, on a segment by segment difference between the final boundary and the parties' claim lines, in this figure, for the analysis on the geoscientific portion that I did of our joint paper, I decided to split it into an area A, an area B, and an area C. So this is the nearshore shallow foreshore waters. This is the deeper frontier offshore waters. And then beyond the 200 red line you see here, 200 mile, is the ECS. So we'll have a segment A, segment B, segment C. Segment A actually is by the court special chambers line is actually east of what Ghana claimed. Then in section B, segment B is west, and segment C is actually east. So you end up getting a, in this analysis, we did some quick geodesy for some areas. Almost 18 square kilometers is lost in area A from what Ghana claimed. A gain of 120 square kilometers geodetic in B, and then a loss again of approaching over 20 square kilometers in C. So this just goes to show that the final line by the special chamber did not coincide even with Ghana's claimed line in the case. So here is just an interesting table that Peter and I did on our analysis, and it does sort of give a lot of information, so please don't be overwhelmed by the slide. But it's basically the differences of the final boundary from the special chamber ruling as opposed to the parties' claimed lines. The first line column here is just showing all the points. So the special chambers modified land terminus point, point A, B, C, D, E, F, and then the interpreted termination. Here's actually how far down the line it is, which is somewhat interesting. There is slight variation in the line, so this is not a straight line. It actually takes a series of swings to and fro from west to east to west to east. More importantly, it's the differences here. Now, of course, Cote d'Ivoire had a complete different approach, so there's going to be huge discrepancies. But you'll see in this table, there's a number of areas that are approaching 500 meters, and 500 meters swinging to what all the current concessions, especially the 10 prospect that Peter mentioned earlier, which is an ongoing development for a known now found resource, is going to make a dramatic impact in our analysis. Figure 3, the affected offshore area here, shows the maritime, the final boundary for the special chamber ruling versus the blocks. Now, there's some blocks that are gains, and there's going to be some blocks that are losses. So the red ones are the losses in this on this slide. On the left-hand side, it's impacting Cote d'Ivoire, and on the right-hand side, these are the blocks for Ghana. So you'll see that there's a few gains and here, and basically a number of losses here, and then here there's a few losses and a few gains. And again, this is based on drilling information that we had immediately at the time. Peter, some comments on this slide.
So to wrap this up, while the special chamber's chosen starting point of the maritime boundary might favor Cote d'Ivoire near shore along this initial segment measuring approximately 30 nautical miles, Ghana received a final boundary that is even more favorable than the boundary claimed by it, along a segment of approximately 164 nautical miles. And as the slide shows, we used information very shortly after the ruling was issued. So even before the ink on the ruling was dried, to make projections as to what the boundary line means for concessionaires on both sides. And we are unaware of any similar analysis that has been done or is on the internet. So this shows how we can project maritime boundaries onto the limits of concessions as publicly shared and published, in this case by drilling info. Rob?
Okay, so law of the sea background information. As we've now just concluded our analysis on the special chamber's final ruling on Ghana, Cote d'Ivoire, we thought it would be fun to take a preliminary look at Ghana versus Togo. That is a still present day unresolved maritime boundary. So this next slide deck is going to be very preliminary. But down in the bottom, you'll see, as we are showing this now in December, we've already been asked to do a more detailed webinar, and we'll do that in January of next year. And there's actually, the webinar will be recorded as this one is. Okay, so very, very preliminary. This is going to be a preliminary regional review on the eastern side of Ghana. There is a Ghana versus Togo maritime boundary escalating dispute, if you will. Step 1, coastlines. Now, from this figure, you will see that we've identified the area Ghana, Togo, and Benin. You see a wonderful inset slide here, a 1 to 5,000 scale from Airbus Defense Mapping. When we do our desktop studies, it's all about present day information. And you can see we need to begin by mapping the coastline. So you can see here from this even better inset, the 1 to 1100 scale, Peter and I mapped the coastline, and we actually located the little green happy face is our suggested land terminus point. Because again, all law of the sea applications for maritime boundaries begin at the land terminus point, as we saw in the previous court case, the emphasis that the special chamber put on that. So in this current slide, we're going to do some analysis for the territorial sea baseline model. The 3 red arrows indicate all 3 land terminus points relevant for our little preliminary study here. Also, this is a mapping application, and we know that the area has old nautical charts. So this is what is something new that we do at Fugro. We've now successfully tested this on 1,200 projects around the world in many countries. What the insets are showing you is present day image showing the nearshore shallow water features to aid us in producing what is called the normal baseline. Now, the blue line that you see along the small portion of coastline, the relevant portion, is mapping that we did, an analysis we did using this imagery, because the coastal nautical charts here are mapped 100 years ago. That's not going to hold up in any court. So Peter and I approach this using this modern day imagery, but it's basically the normal baseline by definition is the low water line, the low water contour line along the coastal state as shown on a nautical chart. Because we don't have that information, we're now having to think out of the box. So we brought in this satellite imagery. And this satellite imagery is showing all these shallow water offshore features. So small rocks, small islands, islets, all those type of things that could be integrated, because that's critical. In some cases, features offshore in 1 or 2 kilometers are going to dramatically affect the way that the line is going to be taking shape for the negotiation for the 2 littoral states. But this basically is step 2, territorial sea baseline model. Step 3, legal limits, we're only going to be showing the 200-mile limit, as we showed earlier in our analysis on Cote d'Ivoire versus Ghana. So taking from all the coastlines here, you can see the red line, and that's the 200-mile EEZ. So that's defined our EEZ waters, and outside here is our extended continental shelf waters. Step 4, maritime boundaries. Now, earlier on, I had already shown in our regional analysis, we know that there's an existing treaty between Benin and Nigeria. So that basically means that that frontier is pretty much defined. We didn't really need the land terminus point, but we did it preliminary anyway. There's also a JDZ shown here. That's an agreement from quite long ago between Nigeria and Sao Tome and Principe. But the analysis for this desktop study is going to be in these waters. So step 4, computed strict equidistance line. This is the starting point for all courts. They like to start with something. And a strict equidistance line is just taking all the facts for coastal state A and state B. In this case, I'm showing Benin versus Togo. And this green line here is actually a coincident line. We get the same line based on Togo's opinion and based on Benin's opinion. And that's, again, based on offshore blocks, but it also coincided with the strict equidistance line. The orange dashed line shown here is actually dramatically in favor for Ghana, but very not in favor for Togo. But this is the strict equidistance line we did using our normal blue baselines here for Ghana and for Togo. And you'll see it swings out, and then this headline swings it dramatically and shifts it to the east, actually crossing the provisional boundary line for Togo and Benin. So that would be a particularly difficult line maybe to justify. A complete opposite one, we're now applying a radical different approach, the court method that was used successfully by the special chamber over on the western side of Ghana. We applied it, used a little tiny bit of points here, and we give a line. Now, interestingly enough, this line does show and give at least Togo access to the 200-mile limit and actually to the extended continental shelf. So that would be something that would bode a little bit more in the likeliness side of an equitable solution. Next, we did mention earlier on heavily that a lot of courts now are starting to look at the extended continental shelf. We already know that there is a dramatic overlap in this area with over 21,000 square kilometers. So Ghana has a claim here. Interestingly enough, what I didn't show in the 2016 opinion, it was only that it happened in 2018. Togo and Benin decided to pair up, and they decided to join forces. So they submitted a joint claim, which you can see by the blue dashed line. So here was, because we know that Togo is trying to reach this far to the west, this black dashed line means that's probably a line that Togo is looking for, at least in their unilateral approach. So they're hoping for something that goes way to the west here. Of course, that's going to then impact Ghana, so there needs to be some negotiations. So the red line there, dashed line, is the strict equidistance line. The yellow line here was our court line, just very preliminary, seeing applying the same logic that happened in the court case on the west. And here would be a line that would be something that Togo would be happy with. Now, when you look at the blocks, and these are the blocks from Drilling Info, the blue ones are Ghana, the yellow ones are Togo, the red ones are Benin. You see we have an overlap here. So this is going to be a problem already. And this is the problem that we are faced with. A zoom in will show that, in fact, the yellow block claimed by Togo is dramatically impacting the blue block as issued to a concessionaire with about a 10% overlap. Now, when that actually happened, that's when the problems arose for that we realized that there was going to be a new pending dispute. And it actually came to be when we were looking at this area, when we came in here for our analysis, what ended up happening is it started hitting the press. Now, why did it hit the press? Well, you can see from this inset that we don't have a problem between Togo and Benin, but we do have a problem with Ghana and Togo. And you can see here that in December 2017 and May 2018, Togo actually intercepted 2 seismic vessels working this blue block here at gunpoint. And that happened, as from the URL web references on the bottom, starting in June 2018. Then they started to try and negotiate. And here's a new piece of information from December. So 1 year ago from almost today. Ghana-Togo maritime boundary dispute for the 3rd time, negotiations failed. And then the latest information that Peter and I had access to, still no progress on the Togo-Ghana maritime border conflict, and that's a press release from 3rd of May, 2019. Peter.
So that slide just underscores where it said Togo invest, that boundary disputes are indeed a investment risk assessment item. And the question there is, what is the impact of the Ghana-Cote d'Ivoire ruling on the region, on other countries that face unresolved maritime boundaries? And interestingly, Benin had written to the special chamber and had asked to be provided with the parties' written pleadings and documents, because it said that the view adopted by the special chamber on the delimitation of the Ghana-Cote d'Ivoire maritime boundary is likely to have an influence on the delimitation of the maritime areas of the sub-region, including that of Benin. But the special chamber pointed out in its ruling that, quote, its judgment is binding only upon Ghana and Cote d'Ivoire and is without prejudice to the rights and interests of third parties, end of quote. And third parties, of course, includes neighboring countries. So in international law, this ruling is binding only on Ghana and Cote d'Ivoire. But that's not to say that a court would not take into account any existing delimitations. But it looks like the case law is limited in this respect to agreed boundaries, that is, agreed boundaries through treaty and not imposed adjudicated boundaries. But needless to say, given that this boundary sits at the heart of the Gulf of Guinea, it is going to be a factor, we believe, and obviously the ruling in its various aspects will need to be considered both by concessionaires and by states such as Togo. Now, Ghana took a gamble by unilaterally instituting proceedings against Cote d'Ivoire in September 2014, and that was only a few months after the two countries had agreed on the terminus of their common land boundary. So that was an apparent trigger for this case. And by unilaterally proceeding against Cote d'Ivoire, Ghana cut short 6 years of bilateral negotiations. But as the ruling shows, that gamble ultimately paid off. And the ruling effectively denies the equitable access to the resources of the Tano Basin in the disputed maritime area that Cote d'Ivoire had sought. And this is a very promising basin worth billions of dollars. Now, finally, just to go back to this, the starting point for the measuring the line, the special chamber chose this very old chart BA 1383 from the 19th century. That actually falls short of the United Nations scale guidelines. But apparently that choice stems from the fact that both countries had relied on that chart until 2014, and they had not jointly surveyed their coasts. So that's a good lesson, a takeaway point from this case, that countries are better off jointly surveying their coasts so that at least they have the best geoscience at their disposal before they make any decision as to what is in the best interest of the country and its concessionaires. And we saw that the special chamber starting point differs from the agreed starting point. So the fact that two countries agree on a land terminus point, means nothing if that point is not on the low water line. So that favors Cote d'Ivoire, the Cote d'Ivoire near shore, but not far away from the shore. And the fact that this new position differs from the bilaterally agreed upon starting point means that the boundary line fixed by the special chamber nowhere coincides with the lines claimed by Ghana and Cote d'Ivoire. So that's another takeaway point. This just underscores the importance of geoscience and of working with the case law to make informed decisions about the options facing coastal states when there is an unresolved dispute. And we hope that our analysis has underscored, the importance of considering both international law and geoscience. So that brings us to the end of this webinar. We would like to thank the Extractives Hub at the University of Dundee for giving us the opportunity to present on this important topic in the Gulf of Guinea. And I would like to thank my co-presenter, Rob van der Pol, for sharing his geoscientific insights with us and for preparing these wonderful figures that we have shared with you, and again that are available for viewing on the Dolphin website if you would like to have further reading of what we have presented today. And I'll leave the final word to Rob.
Okay, thank you very much, Peter. Again, I'd like to thank everyone that is viewing this webinar for taking the time to listen to what Peter and I have to say. I think you've seen quite an interesting analysis from the primary reason why we did today's webinar for the Special Chamber's review of the Special Chamber's final line. Also, I'm hoping that initially you're gaining some insight as to just how big a problem law of the sea still remains present day, with 50.1% of all the world's EEZ boundaries yet to be resolved. Just some quick comments. It is wonderful to work with Peter on this. Peter's knowledge of the legal side of law of the sea, and I bring to the table the geoscientific expertise. Together, we can tackle this anywhere on the planet. So no matter where we're faced with doing these type of analysis, we do normally come out with very, very useful results. Just a couple of comments that these desktop studies, they can be done anywhere. And I think you've seen from our analysis, or at least introducing slightly the new pending one between Ghana and Togo, is something that's going to be front and center now for the next couple of years. But the big thing is there is a light at the end of the tunnel for these coastal states. It does not need to go to the courts. It does not need to get contentious that there is going to be 5 to 7 years tied up in the courts for these sparring neighbors to try and come up with a line that they will both agree upon. And it's usually the concessionaires and the development of the offshore industry that gets clobbered, not to mention the tens of millions of dollars in legal fees for all these years for these court cases. Peter and I have done so many reverse engineering desktop studies around the world. And the interesting thing is we're usually in the 95 to 97% range of our results to what these final lines come to be. So that's just a matter of knowledge of we putting our legal and scientific expertise together. Basically, I do want to refer to, after today's webinar, we hope you will join us in January of 2020, next month, to go and have a look at a very detailed analysis on Togo, Ghana. I would also like to, at this stage, thank my co-presenter, Peter Becker, for another enjoyable webinar. And I would also like on this last opportunity to thank the Extratives Hub for allowing us to present and to publish our recorded webinar. On that note, thank you very much, everybody, and have a great day.